Question 12. I obtained a loan from a Payday loan company and gave them a check which is now insufficient funds. Is this dischargeable? The answer is yes, yes, yes. Payday loans are just an unsecured loan that will be discharged in bankruptcy like any other loan. I'll mention peripherally that if you have received a letter from your local county prosecutor telling you to pay that payday loan or criminal charges will be filed, there will be no prosecution for that. We have a number of Missouri cases that very clearly establish an absolute defense that there is no crime committed. Here's the reasoning of the Missouri courts. When you gave the check to the Payday loan company, they knew at that time that you didn't have the money in the account. That's why they were giving you the loan. So since there was no reliance on the part of the creditor in taking your check, there is no crime, so don't worry about that. But the question itself, payday loans are dischargeable just like any other loan. 13. Are there circumstances where I can pay a creditor less than what's owed and keep the asset? The answer is yes. If you'll review our series on redemption, if you have a car loan or you've owned the car for more than 910 days, you can buy the car in bankruptcy for its value rather than the amount owed. The difference is discharged in bankruptcy. There's all kinds of other cram down options available. The one thing, with one exception, residential home loans, and there's one exception to that, but other than the one exception, residential home loans cannot be crammed down. But mobile home loans, car loans, very frequently in bankruptcy, we're able to reduce the price for you for less than what's owed. The theory of bankruptcy, by the way, it isn't to cheat the creditor, but if we permitted the creditor to repossess the collateral, your car or the mobile home, the maximum he's going to get anyway is the value of the collateral. So the theory of the bankruptcy court is, well, we'll let the debtor have it for fair market value. Why so much emphasis on Chapter 7 when I want to file under Chapter 13? This is a question that I want you guys to understand its significance. Let's take an example. You come in here and you visit with me, and you're late on your car payment or you're late on your home payment, so you therefore want to file Chapter 13. Well, if you qualify for Chapter 7, then the provisions that we put in your Chapter 13 plan will be much more favorable to you. If you do not qualify for Chapter 7, you're still going to be permitted to file Chapter 13, but you may be required to pay at least part of your unsecured creditors. So the significance is important. When you come in with your income, if you're over the median income, then I'll visit with you about that. But that's why we put so much emphasis on Chapter 7. Also in Chapter 13, the last insight I'd like to share with you, you have to pay in Chapter 13 your unsecured creditors an amount they would have received if you had filed Chapter 7. So for example, let's say you had $7,000 worth of non-exempt assets. Then you would have to pay at least that much to your unsecured creditors during the Chapter 13. Now the reality of it is almost 98% of the people that come visit with me, they do not have non-exempt assets, so it's a false issue. So don't be misled by that. In Chapter 13, do I pay 36 or for 60 months? Can the plan ever be changed? Well, 36 or 60 months, if you're below the median income, which most people are, you have your choice as to whether or not you're going to pay for 36 or 60 months. If you want to keep the payments lower per month, then very frequently you'll go on a 60-month plan. When I explain in another part of this presentation Chapter 13 plans, we'll go through some examples so you can see how that works. The second part of the question, can the plan ever be changed after it's approved? Yes, it can. If you've had a change in circumstances after your plan has been approved by the court, if you have paid what your creditors would have, your unsecured creditors, what they would have received in a Chapter 7, then there's a possibility that we can have your Chapter 13 plan concluded before you complete the 36 or 60-month plan. Also, if you buy health insurance for one or more people in your family that you didn't have when you filed Chapter 13, we can then take a look at it, and that opens up another possibility for early termination of a Chapter 13 plan. Are there circumstances in which I can cancel a debt secured by a mortgage? There is one exception to the general rule that you cannot cancel a residential loan. Let me give you an example. Let's say you own a home and its value is $80,000, and your first mortgage is $100,000, but you have a second mortgage for whatever amount. In that limited circumstance where the first mortgage is greater than what the value of the home is, then we could cancel the second mortgage and you wouldn't have to pay a penny. But if there's $1 of value available to service that second mortgage, then you can't cancel it. It's a very strange rule. It doesn't come up very often, but maybe it will come up more frequently now that we've had such a drop in real estate values. So again, understand the rule. If your house is worth more or worth less than the first mortgage, you could cancel the second mortgage. In like manner, let's say you had 3 mortgages. Well, if your first and second mortgages, if that total is greater than the value of the home, then you could cancel the third mortgage. It works that way also. So if you have any, we'll look at your real estate values, and if that rule comes into play, I'm certainly going to let you know about it. I previously filed a bankruptcy. Am I eligible to file a second time? The rule is very simple, but it has a number of exceptions. Basically, it's 8 years from date of when you filed your last petition. So if 8 years have went by, you can file another Chapter 7. Now, let's assume you filed a Chapter 7, and now you have medical bills or some other problem where you need assistance. Well, you can't file a Chapter 7, but you can file a Chapter 13. And we do that very frequently. And then during the Chapter 13 period, if the 8-year limit then comes up, the 8-year time frame, then we can file a Chapter 7 and early terminate the Chapter 13. So those are rules to protect you.